Good afternoon, everyone. It is 12 p.m. Eastern Time, and I'd like to welcome all of you to our September 27th public briefing of the North Carolina Advisory Committee to the U.S. Commission on Civil Rights. Olga Wright, our chair, is unable to participate today, and she's asked me to lead the meeting. We're also having some inclement weather in the state and area, and so it might affect some of our internet connections and some participation, but as it notes, the meeting is recorded, and we trust that people that aren't able to join us will be able to review the transcript. But before we get started, I'll begin with a roll call. As I mentioned, Olga Morgan Wright, the chair, is not in attendance. Daniel Bose.
Present.
Pearl Burris Floyd. Travis Cook. Christopher Duggan.
Present.
Marcus Gadsden. Stephen Green. John Huzet.
Present.
Jennifer Lechner. Angelo Mathey has recused himself. Donna Oldham. Catherine Reed sent a message that she was not available, likely. Mercedes Restuccia, myself, I am here, and Gregory Wallace.
Present.
Great. Going over this explanation, the U.S. Commission on Civil Rights is an independent bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws. In all 50 states, D.C., and the U.S. territories, an advisory committee to the commission has been established, and they are made up of responsible persons who serve without compensation to advise the commission on relevant information concerning their respective jurisdictions. Today is our fifth and last briefing where we will hear testimony related to our topic focusing on the implementation of Rylan's law. Our agenda today is, given that we have a lot to cover in only about 90 minutes today, we will abide strictly to our agenda. Our agenda is different from previous briefings as we needed to accommodate our panelists' schedules and availability. As such, we will hear from the public first, then we will hear from two speakers, and the committee will ask questions. We will then proceed with our last speaker, then we conduct a Q&A specifically directed to her. Some ground rules. This is a public meeting and remarks will be recorded and transcribed for the public record. We are required to obtain the legal names of anyone providing the public comment. Time allotted is 3 minutes for each comment. Comments shared should be comments only and not a Q&A with members or panelists. A 3-minute timer will be made visible on the screen. Speakers will be notified when their time is up. I will reserve the right to provide warnings if a speaker is over time and ask staff to mute the speaker. We ask that everyone respect the time allotted and end their remarks when the 3 minutes run out, as to give others a chance to speak. Though some of the statements made today may be controversial, we want to ensure that all guests today do not defame or degrade any person or any organization. If a specific person or organization is named in a potentially defamatory manner, they will be provided with an opportunity to respond, and this response will be part of the public record. As the vice chair, I reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand via the following process. I will remind the commenter that we do not accept defamatory, degrading comments, and will reach out to the impacted person for a response. If the statement continues in the same fashion, I will give the person a warning that we will hard mute them if they continue. The commenter may be hard muted if needed. After public comment, we will hear from 3 panelists who will present for 10 to 12 minutes. Committee Q&A will be amended due to today's time constraints. Committee members are limited to 1 question. I will go down the roll. As time allows, I will circle back for a second round of questioning. Committee members are asked to be succinct in their questioning. To the extent possible, please direct your questions to 1 panelist at a time. If time allows, we will have a second round of questioning, and members are asked to use the raise hand function in Zoom to express their interest in asking a question. I will call on committee members in the order that their hands were raised. Please notice that you will have the opportunity to submit follow-up questions to panelists via staff after today's meeting. The due date for written comments has been extended to October 28th, 2024 to Lillian Schiller at lschiller@usccr.gov for inclusion in the public record. Based on these proceedings, the committee will meet twice to debrief testimony, then begin to draft a report directed to the U.S. Commission on Civil Rights, detailing findings and recommendations for addressing this topic. A quick message to committee members: please be sure to review past briefing materials, written testimonies, and submitted sources, as we will be meeting to discuss the themes and findings on October 29th and November 15th. As you saw in Anna's August 29th email, she linked you to all these items, which include forms where you will be submitting your ideas for themes and findings. Please submit those ideas via monday.com from now until November 24th. And again, there's a form that that Anna has shared. It was a table, all the links that we need. Again, we can submit our ideas up until November 24th. Drafts of our report will be available for public review, and we are grateful to everyone who has shared their experiences since the beginning of the project. Now we will begin our public comment. Displayed on the screen are audio and visual tips. Based on the time allotted, we will only have time for 4 speakers. To provide a comment, please raise your hand in Zoom. If you are joining by phone, press *9 to raise your hand. I'll now call on staff to assist with public comments. Staff will call on and inform members of the public when to unmute. Thank you, staff.
Great. Thank you, Mercedes. Vice Chair. We have 3 members of the public who would like to offer a comment. Our first speaker is Robert De Soto, and I'm going to stop sharing my slides so that Liliana Schiller can assist with the timer.
Hello.
Hello, you may begin.
Okay. Hello, everybody. My name is Robert De Soto. I hope that you can see me right now. I am putting a picture right here. I'd like to observe a second of silence for my daughter's mother, Ricky Jean Porter. She's, as of yesterday, no longer been here for 5 years. She passed away, and I feel as if I never had called Wake County for help, that I might have my daughter's mother still here today. As I said before, my name is Robert De Soto. I'm a father out of Texas, and I would do anything for my child. Over the years, I've worked so hard just to see my child in a visitation setting. Our life before the parental alienation occurred at the hands of Wake County was good for the circumstances that we had been through. Anyone who had eyes could see the love that my daughter and I had for one another. One of our first court dates, where I had called CPS, I had met Miss Nina Wright. She was a supervisor she was worker for Wake County. And one of the first things she asked me was, what would you do if you were in Walmart and your daughter was called an N-word? And when I answered unfavorably, I was told that from that point forward, we would be having what is called visitations in a supervised visitation setting. It was the last thing that our family needed at that time. I called for help, not to be oppressed. Every day, prisoners are allowed to see their children. Even mental health places and rehabs are allowing children to stay with their parents now to help keep the bond so children have a better future. Since the county has been involved in my case, I've missed out on so many milestones that are integral to my child's development. I was not able to go to her very first daddy-daughter dance when she was 5. I've missed every school start that she's ever had. I've missed graduations. And all of this because Wake County felt that I should not be in my daughter's life. And I was available the entire time. Wake County has terrorized the memory of loving parents. I already have instances of judicial misconduct on my record, seeing as Judge Javidian recused himself for telling me to blame the Chinese for why I hadn't seen my child during the pandemic. I was told by someone he hired to get out of the Republican-leaning courtroom and get into a Democratic-leaning courtroom. I get to Judge Parker's and I was treated as if I was invisible. In my case, there's no contact with my child since her mother's death and beyond, and there's no path forward for reunification. Judge Parker has had the chance to fix these issues, and she put continuance after continuance on my case, magnifying the issue of parental alienation. On top of this, there's been multiple therapists that have practiced outside their clinical axioms and have done harm to my family. My issue is that
Mr. DeSoto, that is the end of your time. Thank you for your comment.
I appreciate
Our next public comment is from Amalia Petian. Amalia, when you see the timer up, you may begin.
Good afternoon. Thank you for listening to me. My name is Amalia Wilson. My children got taken out of the home. This is supposed to be for their well-being, even though every time I went to court, they told me that it was about their father, what he had done. They've required me to do some things, and I've completed everything that they've asked, and still I can't get my children back. A couple of weeks ago, my children made a video that they wanted me to show the judge, because since this thing started, no one has spoken to my children or even asked them what they wanted. Is it okay if I play the video?
I'm sorry, it's only a public comment at this time.
Okay. Well, the investigation.
Oh, I'm sorry. I thought you were trying to share your screen.
No, I just wanted you to hear.
Mother, 2 little siblings. Judge Davidian, we want to go home. Exactly. We don't see no reason why. Our mother is a loving mother. Well, what you gotta say, Danielle? Judge D, can you please pray so we can go home? Please, so we can go home. Judge D, I hope that you can make everything right so we can come home. Good job, Booga. You wanna come home? Judge D, my mother let us come home. Is doing everything right, not everything wrong. She doesn't do nothing wrong. My mother is a beautiful mother. She doesn't smoke. She be good. She cleans the house. She got a big house. And she got a new house. She's a good mom. She's a good mom. And we're gonna go home. We wanna go home. And she's not making us say any of this. Honey, I am 15. If I wanted to lie, I would. But I wouldn't, because I wouldn't be back home. I'm 15. She's 14. We're old enough to understand. We want to come back home.
Not every visitation, it breaks my heart because my children keep asking when can they come home, and I don't have an answer. A matter of fact, my daughter's being threatened to disclose everything we talk about at visitation, or they're not going to be able to go home. At this point, I just don't understand why I cannot have my children, especially since the investigator stated on the stand that my kids don't fear me, they love me, and that I wouldn't coerce them, and that they want to be home. So that's all I have to say. Thank you.
Thank you for your remarks.
Thank you. Our next speaker is Elizabeth McCann Thomas.
Good afternoon. Good afternoon. I thank you for the opportunity to speak. My children were taken April 1st. We were in Judge Parker's courtroom, and I am Elizabeth McCann Thomas. I'm their mom. In January, we started this process. We were reported to CPS as a result of me going after the school system for not abiding by the IEP for my children. And they in turn met that with a CPS report. To sum it all up, my children were removed on April 1st. We went in for what was supposed to be a monitored medication and therapy. And it turned into the gala individual standing up and saying, take my children, after I had testified, the judge said that she was going to take them. My sons, I did adopt when they were 4 and 18 months, and they did have mental health issues when I received them. I adopted them from the state of Michigan. I've constantly gone through them for 11 years to receive the services that they need. Upon them being removed from the home because they were not prepared, because this was not supposed to take place, they were taken to the Swinburne offices. And from there, it went to multiple placements. And the therapeutic foster placement, the therapeutic foster parent threatened to kill my youngest child and told my oldest that he was gay. They have been moved up to 8 to 9 times, and my youngest is going to be moved again. My oldest, when placed back in the Swinburne location, had sex on 2 occasions, and no one can tell me where their staff was. And the young lady is now pregnant, and is possibly my child's child. And he's 15 and she's 16 years old. My youngest was placed, both of the boys were placed in Free Will, which is a place that was not structured and they never should have been in. My oldest tried to set the church on fire because he said that he was hurting and all he wanted to do was come back home. My youngest was outside exposing himself, and they both have behaviors that they did not come into the system with, from bucking up at adults to running away. My oldest ran away. I was told that when they first got him that he didn't run away, and the only way that he came back was because the other kids did not want him to leave with them. And that was in the Swinburne location. So I was charged with neglect because I wouldn't give my children sugar. They were on their medication. It's been repeatedly lied that they were not on medication, and they were on medication. And now here it is. I am working to fight to get my children back. And I feel like CPS and the court system needs to be monitored and how they are handling parents when these situations are held, because I do not feel heard in the courtroom, nor do I feel as though I have an attorney that is actually working for my best interest. And that's all I have to say right now.
Thank you for your comment, Ms. McCann.
Our next speaker is Beverly Alston.
Good morning, Beverly Alston out of Raleigh, North Carolina. I am advocating for the children of Elizabeth McCann, our previous speaker. She is the mother of a 15-year-old and 12-year-old who have been removed and put in the foster care system unjustly. I want to address the facts and not the subjective ideals and perspectives. I believe that the system, meaning CPS, foster care, even the guardian ad litem system, needs to be monitored. There needs to be some checks and balances. This family has been put into undue pressures. We're talking about a mom who herself is degreed, majoring in psychology and minoring in business, with working with major organizations to educate the community on stigmas around mental health. She herself is very knowledgeable. She was raising her children. The CPS case was unjustly done. Her family has been irreparably damaged. The system needs to have a watchdog over them. Kids have been uprooted, taken from all they know, their parents, their grands, their schools, their church, their counselors. Everything in their lives has changed. And then you wonder why the behaviors have increased. Everything she was doing in the home, the system has done and penalized her for doing the same things, i.e. locks on the cabinet drawers and doors in the pantry, which was approved back by CPS back in 2019. And the same is in place with the exception of updates to the equipment in the home, but yet she was penalized for doing what the system is now doing to these children, which was in their best interest at the time in the home. Again, their behaviors have increased because they've been uprooted and changed. Everything. I implore you, there are so many more incidents that could be brought up in this case. However, due to the 45 seconds I have left, I just beg of the system, the civil rights community, to rally to help these parents keep these children in the home and advocate. Everything that she was doing in the home, they are now doing, but doing in a negative perspective because they don't have their home, their family, the ones they know love them. So it's irrevocable damage when you remove children from what they know. And you can't expect children to just hop to when you flip their world upside down. The courts are not helping. The guardian ad litem system hurts as well. I just am prayerful and thankful. God bless.
Thank you for your comment, Ms. Austin.
And that concludes public comment. Thank you.
Thank you all for offering your comments. We will now move into the presentations for our first two speakers, followed by Q&A. Our first speaker today is Representative Donnie Loftis. Thank you, Representative Loftis, for joining us. You have the floor.
Thank you very much. It's an honor to be here and to hear feedback from citizens who are struggling with this humongous system that we're trying to resolve, fix, make better for kids and for their bio parents. First, let me just say that I serve on a couple of committees that has direct bearing for the things we're going to be talking about. I serve on the Health Committee, the North Carolina Child Fatality Task Force, Birth to Third Grade Interagency Council, and I'm a member of the Early Childhood Caucus. And then please let me share that I'm not a Rylan's Law expert or a subject matter expert concerning the information that we'll be discussing today. So when I came into the House in November of 21, one of the things that I was already passionate about was learning more about the foster care system. I served 8 years as a county commissioner, so it was important for me to know how this law came into effect in 2017. It required a statewide reformation of the North Carolina social services system, and especially the child care welfare programs. So troubling gaps and flaws had been identified in the system in North Carolina, and more accountability and oversight was needed for Department of Social Services to produce a better performance and outcomes. So March 1st, 2020, Rylan's Law required regional office to provide closer, more direct regional supervision to those county departments of social services, and understanding that 100 counties has 100 Department of Social Services, and every one of those are both a mixture of state supervision or state policy driven, but they're funded locally, they're hired locally by counties. And so there was a direct drop between the state policy that I felt like the state wanted to be more consistent, or that counties were struggling because the state was not as consistent. And so it provided North Carolina with a blueprint on how it can transform our child welfare system to address systematic changes that was needed in the oversight. And that included a reorganization from 100 counties doing it 100 different ways to more of a regionalized where we had groups of train the trainers and making sure that regional directors reported to East and West directors to provide that consistent training from state level all the way down to the local level DSS or CPS child care worker. In exploring the opportunities of many bio parents and many kinship care parents, grandma, grandpa, aunts, and uncles, it is becoming very apparent that the system is not consistent across North Carolina. And that is one of the things that I've found most frustrating in meeting with my local DSS director, in meeting all the way up through the chief judge for my district here in Gaston County, meeting all the way to former Chief Judge Donna Stroud, who handled all the TPRs, termination of parental rights, and understanding. I've even met with the Administrative Office of Courts. I've even looked at how we hire DSS directors and CPS or DSS employees. How do we do that with the state HR people, and understanding that the quality of candidates means the quality of work we may be getting down the road. And some of that has to do, we've identified, COVID was a big impactor when it came to staffing. Some counties are still struggling with staffing. Funding is another great opportunity, not only from the local level, but from the state level. I shared some information that you may have received already. If not, maybe after this, you'll receive it. It talks about the things that were important that was identified through the Center for Support of Families. They were selected to perform an independent assessment in March of 2018. And at the end of that, they developed 27 different items that they felt like was important to shine light on, to say, if you do these things, we think this will drive a higher performance of impacting children in that system, in the foster care system. So in September of 2018, the Center for Support Families concluded phase one of their work by releasing 2 preliminary reform plans, one for childcare and one for social services. So in the phase 2 part, that was to where we were going to roll that out down to local county levels. And so there was a development of hiring 2 East and West directors for splitting the state of North Carolina, and then breaking the state into 7 regions. This was way back in 2018 through 2020. Just recently have we instituted or put in place these directors of the East and West, and maybe some of those regional directors. So we're already about 3-4 years behind the suggested things that would be helpful to fix this. So all 100 counties, again, operate independently of supposedly following the same law. So all 100 counties had to have a memorandum of agreement, and that they would continue to be able to have their autonomy to be able to address the Child Protective Services, the foster care program. And from where I sit in my office, pre-COVID, we had about 8,000, 7,000 foster parents. Post-COVID, we're down to about 4,000. And from talking with people in that field that are recruiting foster parents, a lot of it has to do with the inconsistent policies from state level to local level, that they're frustrated that they can't really understand the process, or there's no one to walk them through that process. And again, comes back to staffing, comes back to funding for that staffing. Another one of the things that concerned our office was that we were hearing from foster parents, bio parents, children across North Carolina saying something has to be done in order for this to get fixed. And probably in the last 2 months, there was a class action lawsuit. That's part of the information that you'll be receiving. 72 pages that identified my county, Gaston County, and Mecklenburg County, and the DHHS system, that identifies some real shortcomings and some really earth-shaking scenarios of where foster kids were really, they just were not treated well according to this lawsuit. And so we have learned that this is going to be a eye-opening experience of how we do this better. And I can tell you, I'll continue to use our office as a platform to help address how we help bio moms and dads, how we help kinship care. Last year, we got that bill passed, that I sat down with Cody Kinsley, Secretary of DHHS, and said, why do we not fund kinship care? We fund foster care, but who's going to take these kids? Who would be best possible? It would be kinship care, grandma, grandpa, aunts, and uncles. So we got that passed. We also passed
Representative Loftis, you have-
168 million. I'm
Sorry for
sorry.
interrupting. You have 2 minutes, just to give you a
Okay,
warning.
thank you.
Yeah, no, no,
Thank
no,
you.
Thank you.
We also passed $168 million in mental health care, because what was happening was if a child from my county went to New Hanover or went to another county, they did not receive mental health care because it wasn't covered. We now address that issue so that mental health follows that child wherever they are in the system. So I am hopeful that we can identify opportunities to move forward and lessen the burden of this foster care among all these 10,000 kids in North Carolina. Thank you again for letting me share today.
Thank you, Representative Loftis, for your remarks. Coming up next, we have Ginger Rhoads, who is founder of Raise Foster Reform, the Raise Foster Reform Coalition. Ginger Rhoads, you may begin your comments.
Okay. Hi, good morning. Thank you guys for having me. I am Ginger Rhoads, and I am a foster parent, and a little boy came into our home that we fell in love with, and had him for 28 months from birth from the hospital, and he was removed based on the color differences in our skin versus his, which is a direct MEPA violation. We have a federal lawsuit which is in the Middle District of North Carolina with another family. We also have an OCR complaint for the same MEPA violation, and there are now, I believe including us, it's 14 or 15 children in the same county with the same issue. So as I started my journey of fighting for this little boy, we realized kind of in the most organic way, lots of other families, things were happening to, because they started contacting me. They started reaching out to me. People I had no reason to know or meet found me and started telling me their stories. So it became quite clear this was a bigger problem than we realized, and we started the nonprofit Raise Foster Reform Coalition. If you will move to the next slide, please. So in North Carolina's foster care system, we are in crisis, with over 12,000 children stuck in a cycle of instability, constantly moving between foster homes while their emotional, medical, and developmental needs are often ignored. I've spent over 2 years researching the system, speaking with experts, listening to foster parents, and witnessing the devastating impact it has on children. The core issue: a system that prioritizes reunification with biological families, no matter the cost to the child. Children in this system spend years bouncing from one temporary home to the next, only to age out, wind up on the streets, or find themselves in the criminal justice system. In fact, studies have shown that children who age out of foster care without finding a permanent family are far more likely to end up incarcerated or homeless, with 1 in 5 becoming homeless and nearly 50% facing unemployment by the time they turn 24. When children enter the foster care system, it is most often because their biological families have subjected them to abuse or neglect. Yet, from the moment they enter, the plan is reunification, returning them to the same environment that caused their trauma in the first place. This practice can have devastating consequences, as the system often disregards the best interest of the child in favor of maintaining a biological connection, no matter how harmful that connection may be. Studies show 91.4% of abuse and maltreatment occurs at the hand of a parent or paramour. Take the case of an 18-month-old boy who weighed only 14 pounds due to neglect. He was so malnourished that he was finally placed in a therapeutic hospital. Doctors had to reintroduce food slowly over the course of a month to prevent his body from shutting down. Despite this life-threatening neglect, the system's goal remained reunification with his biological parents. The center photo on my slide is that child. Or consider the story of a child whose biological mother overdosed while giving birth. The father, a known pimp and undocumented immigrant, had no stable home or ability to provide care. Despite this, the child was forced to visit their biological parents regularly, leading to severe emotional distress. The child's foster parents, who had provided consistent care and love, were ignored when they raised concerns. The child would cry and cling to their foster family before every visit, dreading the time spent with the biological parents who had brought them nothing but harm. In cases like this, foster parents who try to advocate for their child's safety are often silenced. They're told that children are resilient and won't remember the trauma, even when decades of research on adverse childhood experiences, or ACEs, tells us the opposite. Children who endure repeated separations and unstable placements are more likely to experience lifelong mental health issues, including depression, anxiety, and even psychosis. Foster parents who raise these concerns are often accused of overstepping or even fabricating medical issues, as I've seen firsthand in my conversations with families across the state. As I dug deeper into the system, I started to see a troubling pattern. Social workers and court-appointed guardian ad litems consistently prioritize reunification, even when the biological parents have a history of severe abuse. One example that haunts me is that of a child who was hospitalized for 10 days after being given candy and pills by their biological parent in an attempt to poison them. Despite the parent admitting to this, the system still pushed for reunification, and the child was eventually returned to the abusive home. What's even more shocking is the blatant disregard for medical and therapeutic needs. Foster parents who seek medical care for children suffering from conditions like seizures or feeding issues are often accused of exaggerating or fabricating these problems, even when they have documentation from doctors to prove otherwise. Social workers have testified in court, falsely claiming that foster parents were inventing these issues to delay reunification, deliberately placing children's health at risk. According to data from the North Carolina Department of Health and Human Services, the average number of times a foster child is moved between homes nationally is once every 8 months. However, in counties like Guilford, that number is nearly triple, with children being moved almost once every 3 months. This constant movement causes lasting emotional damage and puts children at a higher risk for aggression, delinquency, and depression, as found in a report by Casey Family Programs released in May 2023. The root of the problem lies not just in policy, but in the structure of the Department of Social Services itself. Each county operates within a fixed budget, and part of that budget is determined by the number of children in care. The more children in the system, the easier it is for counties to balance their budgets and justify employee raises. For instance, some social workers in Guilford County have seen their salaries increase from $47,000 to $75,000 within 1 year, after testifying in court to keep children in care or delaying placements to maintain the budgetary status quo. This financial motivation leads to decisions that are harmful to the children in care. For example, foster parents have reported that DSS refuses to approve critical therapeutic services, even when the foster parents offer to pay for it themselves. Why? Because the goal is not to heal the child, but to keep them in the system until reunification can be achieved, regardless of the child's best interest. Meanwhile, biological parents, many of whom continue to struggle with addiction, homelessness, or other serious mental health issues, qualify for additional social services like housing and medical care simply by retaining custody of their children. This creates a perverse incentive to keep children in unstable environments where their emotional and physical health deteriorates further. The foster care system is a pipeline to prison for many of these children. I I once spoke with a young man, an African-American male who aged out of foster care. He described his experience in chilling terms. Foster care is a lot like prison. You have no choice about where you sleep, what you eat, or who you're with. And when you age out, prison becomes one of the only options you understand. This young man is not alone. Statistics show that African American males in the foster care system are less likely to find permanent homes and more likely to end up in the juvenile justice system or prison. The Center for Study of Social Policy has found that exit to permanent families is significantly less for African American males, a reality that further entrenches racial disparities in the system. Next slide, please.
Ms. Rhoads, you have 2 minutes remaining in your
Okay.
comments.
Thank you. Children in the foster care are being set up for failure, taught that they don't matter and that their voices don't count. This must change. The only way to break this cycle is to adopt child-centered legislation that places the welfare of the child above all else. We need to ensure that foster children have representation in court, advocating for their rights and best interests via a child-directed attorney, enforce accountability for DSS decisions through an independent office of the child advocate, ensuring that child's medical, and therapeutic needs are prioritized. Reevaluate the push for unification in cases where it's not safe, and instead prioritize permanent, loving homes, limiting arbitrary removals from stable placements. The only reason foster parents and DSS exist is because of the children. These children are our future, and it's time we start treating them with care, respect, and love they deserve. It's time for a change in North Carolina's foster care system before more children fall through the cracks. Last slide, please. These are two of the organizations that we have followed, that we've patterned ourselves after. Policy shapes culture. And these two organizations are the gold standard of child-centered advocacy. I have spent lots of time with both of their lead attorneys, Tim Keller and Tom Rawlings, working on suggestions for North Carolina. These men both have decades of experience, not only in state, federal, but also international child welfare law. Thank you so much for your time.
Thank you, Ms. Rhoads, for your remarks. All right. Thank you again, Representative Loftis and Ginger Rhoads. We'll now go into Q&A. For our Q&A, I will use the roll and invite committee members to participate. I see we've got some more on the line. So as a reminder, committee members are limited to one question. As time allows, I will circle back for a second round of questioning. Committee members are asked to be succinct in their questioning as we have limited time, and to the extent possible, please direct your questions to one panelist at a time. At the second round of questioning, committee members are asked to use the raise hand function in Zoom to express their interest in asking questions of one or all panelists. I will call on committee members in the order that their hand is raised for the second round of questioning. So starting with Mr. Bose, Daniel.
Sorry, excuse me. Thank you both very much for taking the time to speak to us today, with such incredible passion and detail. I'll direct my comment to Representative Loftis. You talked about two bills that successfully passed the legislature. And so that means there are probably, 5 good bills that, passed the House but didn't pass the Senate, or got introduced in the committee but didn't go very far. Could you just talk about what some of those bills and where you and what you think the overall appetite is at the legislature for some foundational reforms?
If you'll excuse my technology challenge, we don't have internet because of the storm, so I'm doing by my cell phone. In this session, House Bill 625 came over from the Senate. It was passed in the Senate. When it got to the House, the blazing lightning speed of legislation slowed down considerably because different representatives were looking at different opportunities to impact foster care and the delivery of this care through the social services system. It did not pass in the House. It's coming back next year for a relook, and we're going to be working very hard to get closer to the Senate bill, which I think addresses a lot of those issues. And the timing of this is critical, because when we have what we call crossover day, if a bill doesn't get voted out of the House after going through committees, and then it doesn't make the crossover date to get to the Senate, unless you can attach it to something else, it dies a slow, painful death in either the House or the Senate. So right now, House Bill 625 is one that we're working on. And at the end, December 31st of this year, everything that's in the hopper goes dead. And then we have to come back and refile and start over that process with changes for next year. Hopefully that helps.
Thank you. Christopher Duggan.
Thank you. Again, thank you to the panelists today. My question is directed to Ms. Rhoads. You've expressed a concern at times with reunification for the biological parents in situations such as continuing use of narcotics and those types of things. What is your experience or your research led you to discover regarding reunification with other family members other than the biological parents? And have you encountered that or that being a desirable outcome?
I think if there are family members that are vetted early on and they are a safe, stable placement for these children, those are excellent options because those family relationships are important if they can remain intact. Many times what we're seeing is that there are a lot of unsafe reasons that these children should not be with these families. You know, there are generational mental illness and instability, and so it doesn't always work to the best interest of the child. And so I think it's twofold. One, if we can vet early and make sure that we have stable placements with their kinship, that would be amazing. That would be the best option. But whether it's kinship or a bio parent, if these placements are not safe for them, and we know they're not safe for them, we need to move forward in finding permanent stability for these children. Because what we're seeing across the state is these children lingering in care for years and sometimes even their entire life and aging out because we're just giving those parents one more try to get it right. And at some point, history repeats itself and we're seeing a pattern. And when we see that pattern, we need to respect this child's right for stable family and honor that and give them the love and care they need to thrive, as opposed to throwing them under the bus like they do not matter.
Thank you.
Can I just add that reunification was driven by the federal government? That's why we're all into it. The federal government drives it through dollars and funding. Reunification may be cheaper in reunifying that child with the bio parents. However, like Jennifer has just said, at some point, the needs of that child has to be the number one priority of why we're all here to help them.
Thank you. Marcus Gadsden.
I have no questions at this time.
Thank you. Stephen Green.
Hey, thank you to everybody who testified so far. My question is for Representative Loftis. I do find it encouraging that the legislature is already thinking a lot about these issues and hopefully we'll bring about some meaningful reform. So I guess my question I was thinking about is that this committee will issue a report. And from your perspective as a legislator, what would be, I guess, helpful, in a sense, useful in this report that we're going to produce that would help actually bring about legislative reform on this issue?
So they've already issued that report. It is one of the 4 attachments that I sent yesterday. You'll be able to see the 27 different questions or suggestions. And probably 3 months or so ago, I emailed all those questions to Cody Kinsley, Lisa Coley, Susan Osborne, all those folks who are in that upper echelon of management, and said, where are we with these suggestions? At what point since 2020 have we completed any? What percentage have we done? And the feedback was, well, we are now appointing the East and West directors. So it comes back to what we hear as legislators: we don't have enough money. And it's very frustrating to think of the millions and billions of dollars that are allocated. We haven't moved any further than that. And the whole time, every day in the life of that child is critically important. So I'm going to continue to say, okay, what time tomorrow will we complete one of those 27?
Thank you. John Gusay.
Sorry, I've got a question for Ms. Rhoads. What was the name of that case you referred to where a bunch of families are challenging?
Yes, so there's another federal lawsuit in the Middle Court District, and it is an OCR MEPA violation complaint. And there's also a complaint that was filed through the Federal Office of Civil Rights for a MEPA violation. And there are, like I said, I can't remember if it's 14 or 15 children represented by that now, but there are. And this is where in one particular county, Guilford County in North Carolina, they are removing children from Caucasian families after years of being in care because of the color of their skin not matching. So they are essentially skin matching, which is against federal law. And I would like to add to this that one of the biggest issues with all of the things that we're seeing in foster care is that when the laws that are either state or federal laws are not followed by DSS, GALs, the court system, any one of those involved, there is no avenue. There's no avenue for any reform, for anyone to actually do anything about it. And so it would be very wise for us to tap into the federal 4E funding that already exists and give these children their own advocate. Child-directed attorney would be excellent for each child. Parents have them, but children do not have them. And GALs, from what I have been told from many of them, if they don't do what DSS wants them to do, if they buck them with what they believe should happen with these children, they're done. They're not going to get any more cases, so they can't help anymore. And so we really need someone that is advocating for the children's rights and best interest. And we also need a child advocate, an independent office of the child advocate or ombudsman. It needs to be independent of DSS and DHHS. There needs to be some checks and balances, which we currently do not have in our state.
Thank you. Jennifer Lechner.
Thank you, Vice Chair. I apologize to everyone that I'm not on camera. I have also lost internet because of the storm, and so I'm working off a hotspot on my phone. Thank you to the panelists who have joined us today. Your testimony has been very compelling. This is a question, I think, for Ms. Rhoads. You talked a lot about the best interest of the child standard versus the priority and reunification, and Representative Loftis referenced this as well, is kind of coming from the feds and being dictated by federal dollars. And I'm wondering what the experience, if you know, is of other states and how they balance the best interest of the child versus reunification, and then, or is that just dictated nationally by federal dollars?
So my knowledge of that is this: we are one of very few states who are county run and state oversight. and which means we have 100 little fiefdoms. And the state can make recommendations when they think something should be done differently in these cases. But if the county chooses to ignore it, they have every right to do that. There is no accountability there. And so I think in reference to the federal money and how that works, yes, I think that is an issue, but I think the larger issue is that there is no across the board, here's how we run things. And here are the laws that we are following. There's a lot of interpretation left to individual counties and individual social workers. And one of the other things that we found is many of these social workers are not educated. They will claim to have educational backgrounds, and then when you go and you do a search, there's no educational background found. And these are people who are in supervising positions, and they really are not qualified. So, there's also not enough trauma training. I believe that judges and social workers could all benefit from that, because if they understood the trauma that was happening to these children from day one of just coming into the system, I believe it would make a very big difference in the decisions that are being made.
Thank you. My question next, and is for Representative Loftis. Representative Loftis, our report is to assess the implementation of Rylan's law, and I'd ask, in your personal opinion, I know that you said you don't consider yourself an expert. Do you think that the intent and the purpose for which Rylan's law was enacted is coming to fruition? And if not, what's the primary reason?
I think the premise is great. I think the identifying those things that would impact and change the delivery of service down to that foster child level, it is enlightening. It's just very frustrating as a legislator not to be able to implement that and feel like it is impacting children because of funding, because of COVID, because of short staffing, because of lack of training, because 100 counties are the primary owners of that Child Protective Service, DSS, social worker realm. They want the autonomy of feeling like, since we paid their salary, we want to be able to manage that. And in cases of hiring a DSS director, the state human resource folks can approve or disapprove a hiring director, and that meets the state qualifications. However, county commissioners can override that. And in the case of Cherokee County, there's over $50 million of lawsuits where the county commissioners hired a director. This director was nowhere near qualified, but yet we continued down that road. And in House Bill 625, there were changes there that gave some authority or greater authority to drive DHHS to have consistencies. One of the things that drive that is, I've heard about the liability. If something happens in a Child Protective Services or DSS area, the state is the one who pays that liability, or if there's a lawsuit or there's damages. I've heard discussion of we may take that out and put the liability on counties, because that would drive participation in a consistent across the board policy. So it is important, I think, that we find a way of doing that. And COVID is going to be around a long time, I guess. But hearing we can't find staff, we can't train staff because of COVID. What about this innocent little child who's out in that foster care system every day? That's the person, that's the child. That's who I am most concerned with about how we fix this system quickly.
Thank you. And Gregory Wallace, your question.
Yeah, I too want to thank the panelists for testifying. It's been very helpful today. My question is for Ms. Rhoads, and it's a bit of a complex question. We've heard from witnesses, parents who have lost their children. They've been taken out of the home, and I can't think a person that we've had anybody who has said, look, this is why they were taken out of our home. These are the problems we've addressed, we fixed, and now the state still won't reunite us. Is there any sense, if you, as you've studied the system, you're experiencing the system, to what extent is the correction of the problems, the original problems that caused the child to be taken from the home in the first place, to what extent is that a factor in reunification? And is reunification being done regardless of any efforts on the part of the parents to fix whatever problems precipitated the removal of the child from the home? I hope that's clear.
Okay, I'll do my best to answer. So I think that I will speak in general terms. There are always exceptions, but what we're seeing across the board is that there are plans put in place for parents that have to meet certain requirements to get their children back. And depending upon the social workers involved, they may or may not have to complete those plans to be considered safe for getting their families. There's a lot of discretion and a lot of power within the social workers. And part of the issue with that is that there really are no checks and balances. There's really no oversight. So, for instance, I've seen families that are getting children back, like the little boy that I mentioned to you, who the parent admitted to trying to kill that child. He's back with that family. That should have never happened, but it did. And then there are families that I witnessed one day in court while sitting there for another case. And this lady had worked her plan, dotted every I, crossed every T. But for some reason, that was not enough for her to even visit with her children for a long period of time. So in the same county, they are telling foster parents that they don't remove children from their county. And so they're removing children from foster parents if they move to another county. This woman, because they said they have to all be in the same county for visitations, this woman's had 3 little boys and they were all in 3 separate counties. And she had to drive to all 3 different counties to go pick up her children for a 2-hour visitation, which meant that her youngest, who she picked up first, was in the car for like 8 hours that day. And the judge said, and she asked if she could have an overnight to have a longer visit. And he said, absolutely not. But she could have a little bit longer time then. And she said, the problem is that my youngest son is so done. He can't handle more time because of all the drive time I have to go pick all my children up. And there was no accommodation made for her. So I definitely see there are issues on both sides. There are people who are working to get their children back and they're doing the right things and they're meeting, they're having trouble doing that because things are being put in their way to cause them to not succeed. But I will say, I believe that's the minority. Most of the time we're seeing handholding, and I've spoken to people who are now adults and aged out of the foster care system, and they have told me repeatedly that they wished that DSS had been honest with them about what was happening with their parents and not hand-holding their parents, because it drug their cases on for years because they kept trying to make their parents do all the things they were supposed to do, and they would have failed much more quickly had they been left to their own means to do it, as opposed to hand-holding, because at some point they still fell apart. It drug it out longer. So the children were in care longer without stability because of that. Did I answer your question? Okay, thank you.
I would just add, if I could there, I've gone as far as to say, if we did body cameras, I guarantee you the conversations would change, because like Jennifer says, these CPS workers have sole authority. what they do, boots on the ground. And there's some of them doing a great job and they are working it to the max. But we have some of those outliers that if that body camera was worn, I guarantee you the authority they exercise at times would be limited to how can we help versus make me mad, I'll yank your kids. So I know that's happening. And I'd just like to share that the 4 things I sent as attachments yesterday was the 27 questions or the 27 recommendations, the lawsuit itself, 72 pages, the lawsuit press release, and the termination of parental rights PowerPoint. So it's good information to understand how this is all unfolding.
Thank you, Representative Loftis, for sharing that with us, and I'm sure we will all review it if we haven't already. We are looking at 1:05, and I do not believe, and staff can confirm that we do not have time for our second round of questions. We might have some at the end of our next speaker's comments and question and answer period. And so now I would like to introduce our last speaker who has joined us. I'd like to welcome Ashley Parker, who is the lead child support judge and abuse, neglect, and dependency judge for the North Carolina Judicial Branch. Judge Parker, you have the floor.
Hey, good afternoon, everyone. It's a pleasure to be here. I did want to correct that. I am not for the entire state. I am only for Wake County.
Wake County.
Yes, which encompasses Raleigh, North Carolina, which is where my office is. Thank you for the invitation. It's great to see so many familiar faces. And so for those who do not know me, I just want to give a quick introduction that my name is Ashley Parker. I'm a district court judge in Wake County. I've been serving in that role since 2017 when I was appointed by Governor Cooper. Prior to that, I was an assistant attorney general. And then prior to that, I was an assistant district attorney. I went to Wake Forest for my undergrad, where I studied psychology, and North Carolina Central University School of Law, and where I graduated in 2012. I can't get into my full story of how I became a judge, but I never thought I would be here. But what I will tell you is that I have an intense passion for children. I am a single mother of a 3-year-old and a 9-year-old myself. In addition to the fact that I'm a daddy's girl. So father's rights are important to me. Children having healthy and safe parents to go to. I can tell you right now, there is not a huge lineup of judges who want to do this type of work for abuse, neglect, and dependency. And it is my honor and pleasure to say that I wanted to be here because I really saw a unique opportunity to assist in this system. I think I don't need to tell you all, and I'll keep it 100. Anybody who knows me, Daniel will tell you, Jennifer will tell you, I keep it 100. The system is broken. There's a lot of work to be done. I'm just one person trying to do my little part. There are so many things that are so wrong, but I'm hoping that we can get good people who will stand up and do the right thing. Individuals that I see that you have had serve and to talk about the different nuances of this system. It's so many different things. And so I just want to tell you that I'm only speaking for me, and I'm only speaking from what I'm seeing in my courtroom and what I try to do for me. I cannot speak across the state. I can't sit here and say that everybody is doing it right. I can't say that. I can't say I'm always trying to do it, always doing it right, but I can tell you that I'm definitely trying. The first thing that comes into place is understanding that currently with Wake County, the way that it works, we have 2 judges that rotate every week, week on and week off, myself and Judge Davidian. We each have approximately 500 cases. That's 500 children either in the system or in kinship care that are on our dockets. Our weeks are packed full with cases, and we are doing our absolute best to definitely follow the statute. Number one, first and foremost, to ensure the health and safety and well-being of these children. And then secondly, to reunify and to work towards reunification. That is key and critical to support these parents who I have personally witnessed suffer from themselves typical generational curses is the best way that I can say it. Severe mental health that has translated into substance abuse, the lack of treatment for them, the lack of resources for them that translates into children, unfortunately, being entered into our foster care system. As Ginger mentioned, extremely traumatic. For children to be removed from kinship placements, from family, from friends, from those dynamics to be placed wherever, understanding that we are in a foster care deficit as well. I am in Wake County. We do have more foster parents, but understanding smaller counties do not have those resources. So you do have children who are being separated and put all over the state. I have children all over the state. I have children in PRTFs in different states because there's not enough in our own state for them. So it makes it difficult and challenging for visitations and those type of things. So, you know, you have that issue. But the first and foremost thing is I'd like to tell the parents that my job is to get your children back to you in a safe and healthy way. And our job here, my job is not to judge, my job is to help you. And the way that I plan to do that is we're going to give you all the tools that we can give you, and it's up to you to build the home that you need to have for this child, right? Your children need you. My top priority is remembering that I am not there for anybody else other than those children. And like I said, as a mother, as a father's rights, as a daddy's girl, myself, I am so proud to talk about the fact that in my courtroom, that we have had high reunification with individuals that it would have never looked like they would have been able to reunify with their families. For example, I had one mother with 4 children under the age of 5, who was in a wheelchair, who was a paraplegic. And throughout the life of the case, through supports, through her own strength, through therapy and counseling, she now has her children, and they are doing great, and they are doing well in her care. And we are so proud of that, understanding that there were so many people that told me, Judge, there's no way she's going to be able to do that. And she is in fact doing it. I've had fathers who were locked up at the time that the child was born, didn't even know they even had a child. And through the process, through all of the resources that were able to be provided to those fathers, they are now single fathers raising their child in the home and thriving, and that child is doing great with those fathers and with those parents. I have other individuals who have obtained guardianship or custody with consent of the parents, with people who weren't even related to the child, but just love the child. It's just amazing to see what supports can be put in place. I can say that it's important to me to be culturally competent, have a culturally competent courtroom, to ensure that children who are from different backgrounds and homes don't necessarily need to be removed, have different cultures, don't necessarily need to be removed from a placement, but that placement needs to be well aware of what are the specific needs of that child. For example, I had one child who spoke Spanish, and she was placed in a home that did not speak Spanish. So we made sure that there was tutoring that was put in place so that she did not lose her language. In addition to that, she had a quinceañera, and those type of things. So it was just making sure that, what does this child need so that she still has that cultural background. In Wake County, we have the Wake House, which is our visitation center that has a kitchen. And so we encourage the parents when they come in to cook those foods that are specific to their child so that they don't lose those cultural, those things that are extremely culturally important to them. Additionally, it's not just something that I've done for me, but I've also trained other judges on ensuring that they are culturally competent and being aware of things that they need to be aware of. I'm also proud to say that I am teaching, I do teach vicarious trauma and informing judges and other individuals about that. And AOC, the Administrative Office of the Courts for North Carolina, I'm assisting them with creating a trauma-based curriculum that will go out to all staff so that we can make sure that we are informed of the traumas of the individuals, the parents that come into our courtroom, the children that come into our courtroom, and so that we can meet those needs, but also being aware of our own trauma and the things that we are seeing and handling. I can tell you that I have seen the unthinkable, have definitely lost sleep at night from the things that I've seen and the traumas that I've seen occur to our children. But at the same time, I'm still trying to do my best to make sure that I follow the statute, follow the law, and continue to put our children first. I can tell you that this job is challenging, and not only just the material that you're handling, you're doing your best with limited information with what you have following the statute. In addition to that, you have individuals who do not know you and yet will go out of their way to comment on your social media, my personal social media about my own children, or will do other tactics to disrupt and distract from the work. But I will tell you that there are individuals in the system who are trying to do the best they can from inside. And I am proud to say that I'm one of those people that I got into the system to help it, to change it. I'm one person. There are many others. But yes, there are so much more work that needs to be done. There's so much more funding that needs to be done. There's so much more accountability that people need to be held to. And I will tell you that I'm doing my best to do my part in the county and in the jurisdiction that I'm in.
Thank you, Judge Parker, for your comments. We are going to go into Q&A. Again, members, please note that the same rules apply. I'm going to use roll call. You will have one question. If we have time, we will go through for a second round of questions. ask that you raise your hand via Zoom. So Daniel Bose, your question.
All right. Thank you, Judge Parker. My question is, you talked about limited information that a judge has to act on. And I'm just curious, how do you remain sort of appropriately separated and skeptical of the attorneys for the state? Just because they're there all the time, it's sort of, it's the same, and they just run through the docket. How do you maintain just appropriately skeptical of their testimony? Because one thing we've heard today is just how much discretion they have. So yeah, I'll stop there. Thank you.
No, thank you, Daniel. I would say it's not like the DA's office. This is not like criminal prosecution or anything like that. I'm skeptical of everybody, right? And then luckily I've got 3 different tables. So I've got the county table, I've got the GAL table that's completely independent, that is in the best interest of the child, that is a completely independent office, they have their own attorney, so that is the child's attorney. And luckily in my courtroom, we're able to have 3 different tables as well. It's not just like a mystic, kind of what does this look like? I physically see the county table, the GAL table, which is directly in front of me, and the parents' table. Right. And I think that the judge sets the tone. So for my courtroom, everybody knows I don't play. So they already know to come in correct, come in with information and facts to back it up. And if anybody is telling me one thing or another, that's my job as a judge, is to use my discernment and common sense and reason and experience of the last 7 years of being a judicial official to read the room and make understanding of that. In addition to that, foster parents have an opportunity to speak in my courtroom. I need to know what's happening. Is there anything else going on with the child? Is there anything that's not? Everybody has an opportunity to be heard. Everybody has an opportunity to rebut or, say what's going on. And I take everybody at that same level of anybody could be telling me something that's not correct. One thing I will say about the GAL office in my county, and the expectation of that is that they don't go along with anything. They literally fight it out, okay? Because they're in the best interest of the child. They will go at it. Everybody will go at it, and has no problem doing that. And so I can't speak for every county. I can only speak for my experience in my courtroom. But no, nobody is getting carte blanche what they want on any day of the week. I make the final decision because at the end of the day, these are my babies. And I see every single child on my docket just as the same as I see my 2 children. And I want them to have every opportunity that my children have and more, because they need it and they deserve it. They didn't ask for these circumstances. So for me to just sit over here and sign off on it just because they're the county, it doesn't make sense. Additionally, I would say, Daniel, in my county, we have 5 county attorneys. We have 3 GAL attorneys, and then I have about 6 parent attorneys. So all of us work together and we all see ourselves as working for the best interest of the child, understanding everybody's independent role, but understanding that at the end of the day, my name is on this and I want to make sure that it's done right and done appropriately.
Thank you. Christopher Duggan.
Yes, thank you. Judge, this might be a 30,000-foot question, but obviously we're a commission on civil rights. And can you maybe provide, I guess, an example of the impact that the system has in your experience on specific civil rights of either the minor or the parents or whatever example you want to use?
As far as issues or?
Right, general issues.
Where do I begin? How much time do you have? I see the biggest issue that I'm seeing right now is the lack of funding for mental health. That's what I would say is the biggest issue that I'm seeing right now. Every single parent that comes, not every single, because I have to look at every case individually, which I do, but I would say most of the time I'm requesting a psychological evaluation of the parents to try to get to the root of whatever's going on, because I know that the substance abuse is just a Band-Aid for whatever other traumas have gone on. In my courtroom, I have a lot of children who have been sexually abused by their parents. And when I go and get that psychological evaluation, the parents were sexually abused, right? And now these children are perpetrating on their siblings. And then there's a likelihood that they're going to perpetrate. So it's important to make sure that my judgments and that my recommendations, that it takes in consideration the psychosexual evaluations that need to take place in specific therapy for those children. Here's the problem though. What does Medicaid cover? How many therapists do you know that are doing that's going to be covered on Medicaid? On top of that, the therapists are now going out, and I'm just saying they're making more money doing, whatever else they're going to do. And I get it, right? But then I've got kids who are finally opening up to their therapist, and the therapist is gone, right? And so then we've got these facilities where people, the turnover is insane, right? The people are not getting paid. And then if you even go back to the basis of a social worker, they're not getting paid enough, right? So then you're saying, okay, well, the social workers aren't doing what they need to do. But you're also not getting high quality possibly because you can't retain people at a certain salary, right? And so if you're paying people more, you get a higher quality, and then you get a higher standard, and you get, you know, people that are doing the work more, and are doing a better job at it. So from a civil rights perspective, I definitely think the funding is key for this system. You know, I'm not going to get into, you know, abortions and those type of things. I'm not going to get all into that. But what I am going to say is that our system needs funding for the foster care system, for reunification, for mental health, so that our children are not affected. We are going to see this for years and years and years and years to come. There's a reason why our children are ending up in the criminal justice system, and it's because of what's happening in the family unit.
Thank you, Your Honor.
Marcus Gadsden.
Judge, thank you for taking time out of your schedule to be here, and I commend you on your passion for this subject, which I deeply appreciate. I wanted to ask about your experience observing racial bias in the way that kids are treated and in the way that parents are treated in your courtroom, because I'm trying to understand, you mentioned that there's a concern around cultural competence. And we've had some other folks testify to the effect that they really believe that race has shaped their interaction. So could you comment on how you've seen that play out in your courtroom, and tell us a little bit about your experience with that?
Absolutely. So I can tell you that I am a Black woman. And therefore, as a Black woman, I myself have experienced discrimination, even in just the fact of people not even believing that I should be a judge or should be in this role. And I can see the disdain. A white judge asked me several years ago, what's it like being a Black female judge? And I was like, how much time do you have? But in short, it's very challenging, right? Because I can see that people don't take me seriously. In addition, I was 30 years old when I became on the bench. I'm now 37. So then you also don't know, if I don't know if it's ageism, sexism, or racism. I don't know which one I'm getting. Right. And so you have all these different issues. And so for me, it is concerning that I see it, right? And so I've taken it upon myself to make sure that I'm educating, I would say, the legal profession, judges, attorneys, et cetera, and so forth, on the issues that I'm having, and helping them to understand that if I'm having that, the citizens are having that. The people that are appearing in the courtroom are having that, and we need to be made aware of that. So what I will tell you is that in my courtroom, obviously, because I experience it and I have the experience, I'm very mindful of it. I can't speak for everybody else and whether or not, and I'm doing my best to educate judges on the fact that they need to be aware of the fact that even though you don't feel like you're racist or don't feel like that's an issue, it is likely an issue, right? In Wake County, what I can say is that we do have a very diverse bar of attorneys that are in there. We have a diverse amount of social workers that are of different races, and all of that. But I also feel like, once again, as I said earlier, the judge sets the tone. And so I have made it very clear that race and anything along those lines, or disability or whatever, will not be tolerated, that discrimination will not be tolerated in my courtroom, and that I have no problem returning. I don't care if you blue, black, purple, green. If that child is safe with you and you have done the work that needs to be done, that child will be returned to you. But I will not sit here and say that there is not racial discrimination, or say that there are not instances where people feel like that is the case. I will not sit here and say that that is not a reality.
Thank you, Judge President.
Thank you, Judge.
Stephen Green.
Okay. It seems that we have problems where sometimes kids go back to their biological families where they shouldn't, and sometimes kids do not go back to their biological families where they should. How, from the perspective as a judge in your courtroom, I don't know what needs to change. Like, we're never going to be perfect. We're never going to have a perfect foster care system. But how do we make sure that more of the kids who really should be going back to their biological families are, and at the same time, we're not putting kids back in unsafe situations?
It's a great question, and I wish I had the full answer on it. But I can tell you from my perspective, the statute says that within 12 months that I need to make a decision on permanency for the child. If somebody's been on drugs for 8 years, right, and the child was substance affected, am I really in 12 months going to believe that this parent has stabilized and gotten off of the substances? It's not a reality for so therefore, before I'm even looking at a termination of parental rights situation, I don't do it within 12 months. generally. I want to give that parent every opportunity. So that might take a little bit longer, right? Than the statute might say, because it is a case by case basis. And so to your point, I think sometimes you need to take a little bit more time to see if this parent is going to do that. Not just that, I have a parent right now who's getting ready to graduate from drug treatment court, who has done everything that she needed to do to get her 7 children back. And we're super excited that she's in trial home placement right now. But guess what? It took a little bit longer because she's been on drugs for a long time, right? And so I wanted to see that stability. I wanted to see that, and I wanted to give her the time to do that because she was on the right track. It's looking at that progress and moving forward, and that's the piece. Now, the other thing, though, is that I can think that everything is checked off, right? I can feel like, and everybody's saying everything looks great. We've done our visits, you know, we've done everything that we need to do. The mother and father have been really putting in that work, and I give the child back, which has happened. And 6, 7, 8 months, a year later, I have a case, you know, they're back in, right? And now it's going to be harder because it's going to take longer now, right? And those children are re-traumatized, and the fact that they were out, and, you know, and then they were back with their family. And then because of DV and because of whatever else, we've given them everything that we can give them, but there's nothing else I can do. Now they're back in there again. You know, there's those challenges as well. And so I really think that there needs to be more time and consideration taken into each individual situation, and not just this understanding it's not a blanket situation of 12 months. And that you're going to be able to check off boxes. It's not a box checking off. These are individuals, these are children, these are lives. And so taking that time, I hope will prevent kids from not going back home when they need to, or from going to a home that they should not go.
John Guzay, thank you.
Thank you, Judge. I'm going to actually pass on what I take to be a question from Ms. Rhoads. She points out that in most counties in North Carolina, the guardian ad litem office is housed in the DSS office. And I think her question is, can they really be regarded as child advocates under those circumstances? Is that fair?
I can't speak on other counties. I can't speak on, you know, where people's individual, I can't speak on people's individual situations or what other counties have. I could just say that they are tasked to be an independent organization. They are tasked to be independent officials, whether or not that is the case. I think Representative Loftis was saying earlier, as far as every county doing their thing, their own individual. I think there's a culture within counties on how things are run and that kind of thing. I think I'm from Hickory, North Carolina. Sometimes we call it the good old boy system. I'm not saying that that's what's happening. I don't know. I can just speak for my county that it is completely separate. They are completely separate offices within the courthouse in separate spaces, and they operate independently. And that is how I'm able to make my decisions, because it is an independent, they're independent individuals.
Jennifer Lechner.
Thank you, Judge Parker, for coming and talking to us today. You touched on this a little bit in your introductory remarks, but we've heard testimony, frankly, from almost every witness about the lack of standardization across the state, particularly in the county DHS offices. Can you talk a little bit about best practices in your courtroom, and then how you are sharing that across the judicial branch, and what, if anything, is the judicial branch doing to try to incorporate or standardize best practices across the state?
I can't speak as far as the standardization across the state or what AOC is able to do legally. I'm not quite sure, especially because the DHHS offices are individual with a I definitely think it's an issue of top down, right? Like whoever your director is and their standard definitely translates down onto staff. And I've had, you know, parents complain about, well, the social worker said this and the social worker doesn't do this. And I definitely hear them out. I have GALs, the attorneys saying, social worker, why have you not taken this child to the dentist appointment? And why are you not doing this and not doing that? And I allow everybody to make sure that they are heard so we can address that. I think because that has taken place in my courtroom, there is that additional level of accountability. Like, we don't want to get embarrassed in court, but you will if you have not done what you needed to do. And so I think that the standard that has been taking place in my courtroom over the last 2.5 years is to make sure that you are able, if you want credibility in front of me, that you need to ensure that you are doing your job, that you are doing it properly, that you are doing it with a standard of excellence, and that you are catering to the needs of that child first and foremost in determining what's going on. And if you don't know the answer for that, then I have always allowed motion for reviews, which is a legal standard that they can do, to bring that into my courtroom prior to the 3 months, 6 months, or 6 months that's statutorily required, to make sure that I'm touching these cases on a more frequent basis if there are issues. And so I think having that atmosphere of transparency, but also expectation and accountability is establishing that. I will say that we do have training through the School of Government. I just actually got back from Cherokee, North Carolina, where I learned more about the ICWA, the federal ICWA, Indian Child Welfare Rights Act, to make sure that we are, ensuring that the tribes have the rights that is fairly mandated for them. And so we are deep in training. I am not only certified in juvenile in juvenile welfare, but I'm also one class away from being certified in advanced training as a juvenile judge. And so the training piece is really from the School of Government. I think that is how they are trying to make sure that we are standardizing it. But I will say that they are immersing us in that, helping us understand the cultures, helping us, we're talking and having discussions and holding each other accountable and saying, no, I don't know if I would have done that. And I think that's helpful, so that judges are doing the best that they need to do and setting that tone for their courtrooms.
Thank you, Judge Parker. My question is up next. So, our report is meant to focus on the implementation of Rylan's law, which part of it includes, I believe, 3 visits supervised visits with a social worker before family reunification. And I'm curious, it sounds like you were appointed right at the time that Rylan's law went into effect. So I'm curious if you see that requirement is benefiting or hindering the process of parental reunification when appropriate.
I can't speak about it statewide. I can just say that the social workers that I have in my courtroom are doing those type of visits consistently anyway, right? And so if we are already in the place of, and we stair step it, right? So you're looking at supervised visitation, monitored visitation, unsupervised, and I'm the one that's got the hand in all of that. So I'm seeing each step. That the social workers are not getting that discretion in figuring that out. Is brought before me, and I'm making that determination on whether we are at the next level. And so with those unsupervised visits, then we start with the, then we're going to do weekends and see how that, we're stair stepping for the children as far as that happens. What I can tell you as far as Rylan's law is I definitely understand the purpose of it and why it was there, but I will also say that it is not going to prohibit me. It's not going to stop if the Rylan's law visit has not been done, but the parent is doing what they need to do. I'm not going to delay this another week, so that the child cannot be reunified with a healthy and safe parent who's been doing what they need to be doing for an extended period of time that I've been monitoring and making sure and having my hand in. Maybe I'm a micromanager, I don't know, but my hand is all in the pot. So before it even gets there, I'm going to make sure that they are in a great position. But also in addition to that, I want the parents to know, and I definitely foster that environment and hearing everybody's take. Usually everybody is agreeing, right? So the GAL's agreeing, the DSS attorneys, the parents, attorneys, everybody's agreeing if there's going to be reunification. But the other thing that I definitely take into consideration is the parent. And so I had one parent who, she had 2 children. And she said, Judge, I can take one child right now, but I can't take the other one. Is that okay? And I said, that is not going to prevent you from reunifying with your child. We need to do what's best for you. You tell me what's best, what's working on that. I had another parent, they were getting ready to do the Rylan law visit, the second one. She was getting ready to reunify with her child after so much hard work. She'd done an amazing job and had been diagnosed with a severe health issue. And so she said, Judge, I can't do it right now. I said, girl, whatever we need to do for you, you tell us when you're good, when you're feeling good, and we're going to make sure that baby is spending that critical time with you, and those kind of things. So it's also just a matter of balancing. It doesn't have to be, it can't be so regimented, right? You have to be flexible with these families to ensure safety, but also to ensure the best interest of the children. And so I think it just takes that flexibility.
Thank you, Judge Parker. And our last question, I'm realizing now we are about 4 minutes over time, but I do want to give Mr. Wallace, please, the last question.
Well, thank you. I appreciate that. Thank you, Judge. Besides the solution of cloning you for all 100 counties in North Carolina, it seems like to me that in these cases, the ball starts rolling with parents making bad choices that lead to abuse and neglect. My question is, and I understand that many of them have difficult backgrounds in which they were also abused or neglected. But my question is there anything that from where you sit that the law can do to hold parents more accountable, to incentivize better behavior among parents so these cases don't arise?
Well, I would say it's a mixed bag. So yes, Mr. Wallace, you do have parents who are just, I hate to be like this, but like are just not great parents, are not good people. You have those who are just unable, they just don't have the tools, they don't have the mental health. Like I have some parents, I had one mother who was just, she just didn't have the mental health. So she has a low IQ. So not that she didn't want it, she loved her child, but she didn't have the IQ. And so she had a guardian appointed to her, she couldn't be returned to her child. But I'll tell you something else that I'm seeing, and I'm sorry y'all, I'm over time, but if I may. The other thing that I'm seeing that is extremely challenging is that there are children with severe mental health issues that are not able to go home. So I have so many very homicidal and suicidal children currently on my docket that are unable to be returned to the home, not because the parents don't love them, not because the parents aren't for them, but that the child just cannot return. And I think that that is where the system is extremely failing those young people who are not able to get the resources and the support that they need, and hospitalization is just not meeting the needs of them as well. And so I think there's just so many different categories of that. And I would say that the bulk of the cases that I'm seeing are the latter two, of just parents that do love their children, but just don't have the capacity, versus it is just those who are just horrible individuals. I do see that. I see the people that are raping their children and are physically abusing their children and are just don't care anything about it. But that is a smaller percentage. The other thing I'll tell you that I'm seeing really quick, guys, is I'm seeing a lot of adoptive parents returning children like they're dogs in a pound. And that is extremely problematic as well. And I'm very clear on the fact that that is completely unacceptable, that you have chosen this child and we are re-traumatizing them by not only were they, neglected by their parents, right? Then terminated, the rights were terminated, chosen by someone to be adopted. And because they are now teenagers, they're not cute little babies anymore, that you're sending them back and saying, CPS, come pick them up, or I'm leaving them at the hospital, I'm not going to pick them up. It's completely unacceptable. And so I definitely think there needs to be accountability from the legislator for those parents who have been receiving adoption payments for all of these years and then decide that they want to return the child into the foster care system and continue to receive those payments is unacceptable.
Thank you, Your Honor. And thank you everyone who participated today. I appreciate you allowing us to go a little bit over time. I think we could hear about this topic for hours. Please know that you can submit comments in writing, follow up, and also to the committee members, we can submit follow-up questions in writing to our presenters. Again, please visit our project page in the Federal Register to stay abreast of future meetings where we will debrief testimony and discuss our report. And we appreciate your time and attention. Today's meeting is adjourned at 1:37. Thank you.
Thank you.
Thank you, everyone.